Your sister signed the NDA. It's done. And if you keep pushing this, I will make sure neither of you ever works in this city again." He said it the way men who've never been held accountable say, everything like gravity itself was on their side. He was wrong about that. My name is Mason Holt. I'm 32 years old. For 6 years, I worked as a forensic investigator for a white-collar crime unit attached to a mid-sized regional firm in Charlotte. I reviewed falsified financial records, traced ghost contractors, rebuilt document trails that companies spent millions trying to bury. I was good at it. Quiet, methodical, patient in the way that only people who've watched the wrong person walk free too many times ever learn to be. I left that work 2 years ago. Burnout mostly. I moved back to Raleigh, took a low-profile compliance role at a logistics company, and spent my weekends watching my younger sister Carrie build something. She was genuinely proud of a junior marketing position at Caldwell & Vance, one of the fastest-growing regional advertising firms in the state. She'd worked toward that job for 3 years. Interned twice. Rewrote her portfolio 4 times. When she got the offer, she called me from the parking lot of a grocery store, crying in the best way. 14 months later, she came to my apartment on a Tuesday night with a cardboard box of her desk belongings and eyes that had gone somewhere far away. She didn't cry. She just sat on my couch and stared at the wall, and I knew that look. I'd seen it in deposition rooms. I'd seen it on the faces of people who'd been told that what happened to them didn't count. She told me what she could. The rest came out slowly, over days. Derek Vance was the son of one of the firm's 2 founding partners. 26 years old, no real title, but a corner office and a habit of appearing wherever junior female employees were working late. He'd been friendly with Carrie at first, the kind of friendly that looks like mentorship from a distance and feels like a slow encirclement up close. When she made it clear she wasn't interested, the friendliness stopped. What replaced it was subtler and uglier. Assignments reassigned. Her work submitted under a colleague's name. A formal complaint she filed in March that HR acknowledged, reviewed, and quietly filed somewhere it would never surface. By April, she was placed on a performance improvement plan. By May, she was terminated for failure to meet revised benchmarks. The benchmarks had been revised 3 weeks after she filed the complaint. Before she left the building on her last day, someone from legal placed a document in front of her. Non-disclosure agreement. Confidentiality clause. A small severance check that amounted to about 6 weeks of salary. She signed it. She was 27, alone in a conference room with 2 people she'd never met before, and she signed it because no one told her she didn't have to. That night, I made one phone call. To my former colleague, a woman named Priya, who spent 4 years doing employment law before moving into HR compliance consulting. I didn't tell her everything. I just asked her one question. If someone signs an NDA under conditions of duress, without counsel, and the underlying conduct involves potential criminal behavior, is the agreement enforceable? She was quiet for a moment. Depends on what you mean by criminal behavior, she said. I mean retaliation. I mean possible fraud in the termination documentation. I mean a pattern. Another pause. Call me tomorrow, she said. With everything, I want to be clear about something. I didn't go into this with rage. Rage is inefficient. It makes you sloppy, and sloppy people tip their hand before the board is set. What I felt was something colder and more focused, the same thing I used to feel when I sat down across from a document trail that a company's legal team had spent a year sanitizing. The feeling that somewhere in the mess, the truth had left fingerprints. It always does. I started with what I could see publicly. Derek Vance had a LinkedIn profile that hadn't been updated in 2 years, which was interesting for someone supposedly working in business development. His father, Richard Vance, had given 3 interviews in the past 18 months about the firm's commitment to workplace culture. The firm's Glassdoor page had a cluster of 1-star reviews from a very specific window, all from former junior employees. All female. All vague in the way that reviews written under the threat of legal action tend to be vague. I printed everything. Then I went deeper. Priya connected me with a friend who did EOC filings. Between us, we identified 2 former Caldwell & Vance employees who had filed charges in the past 3 years. Both cases had been settled, both women had signed NDAs. Both were still in Raleigh. I didn't contact them yet. I needed to understand the full shape of what I was looking at before I put anyone else at risk. What I found over the next week changed the scope of everything. One of my former colleagues from the fraud unit, a man named Ellis who now did independent digital forensics, owed me a favor from a case in 2021 where I'd spent 2 weekends helping him reconstruct a destroyed email archive. I called it in. I gave him nothing that required a warrant, nothing that crossed a line. I asked him to pull what was publicly accessible: archived web content, court filings, business registration records, any professional licensing history associated with the Vance family and Caldwell and Vance as a corporate entity. What came back 3 days later was a thread I hadn't expected to find. 4 years ago, a former employee named Lindsay Marsh had filed a civil suit against Caldwell and Vance. The suit was not about harassment. It was about something more specific: the falsification of a client performance report that had been submitted to a vendor partner to justify early contract termination. The vendor had lost nearly $200,000 in anticipated revenue. Lindsay, who had been the account manager, claimed she'd been instructed to alter the numbers and then terminated when she refused. The case never made it to discovery. It was settled in 30 days, confidentially. I sat with that for a long time. Because here's what that told me: this wasn't just a pattern of one man behaving badly and a company looking the other way. This was a company with a documented history of using legal instruments, NDAs, confidentiality agreements, rapid settlements to contain damage. The retaliation against Carrie wasn't an accident or an exception. It was a process. Someone had done it before, and the process had worked, so they kept using it. I built a timeline. Every event I could document. Lindsay's suit, the 2 EEOC filings, the dates of Carrie's complaint, the PIP, the termination, the NDA signing. I mapped the names of the HR personnel involved in each instance. 3 different names. One legal contact who appeared in all 3. A woman named Sandra Oakes, outside counsel retained by Caldwell and Vance for what their invoices, which I found filed in a routine court exhibit from an unrelated contract dispute described as employment separation matters. Sandra Oakes had been paid, conservatively, across 3 retainer agreements in 4 years. I printed that page twice. Then I waited. I know that sounds strange, but waiting is part of the work. You don't move until you know exactly where all the pieces are, because once you move, the other side starts moving too, and if you're not ready, they'll outmaneuver you with resources you can't match. Richard Vance had a law firm on retainer. He had relationships in the business community. He had a son he'd spent years protecting. What he didn't have was any idea that I existed. I reached out to Priya again. She reviewed the timeline and connected me with an employment attorney named James Whitfield, who took plaintiffs' cases on contingency and had, as Priya put it quietly, beaten Caldwell and Vance's preferred outside counsel before. I sent James everything in a single encrypted file. His response came back in 4 hours. This is more than enough to reopen. The NDA has significant enforceability problems given the documented retaliation timeline. I'd like to talk this week. I called Carrie that night. She was staying at a friend's place and hadn't left the apartment in 4 days. I need you to trust me, I said. I need you to not sign anything else, not respond to any calls from the firm or their lawyers, and give me 2 more weeks. She was quiet for a long moment. Mason, she said. They have lawyers, they have money. I know, I said. And right now they think they've already won. That's the only advantage I need. I want to tell you about the moment things really shifted, because it didn't happen in a courtroom or a conference room. It happened in a coffee shop parking lot on a Wednesday afternoon. I had arranged, through a carefully worded message sent through a mutual professional contact, to speak briefly with one of the former employees who had filed an EEOC charge. Her name was Angela. And she agreed to 15 minutes, off the record, just 2 people talking. She was cautious. She had every reason to be. But she came. She told me she'd been with the firm for 2 years. She told me about the reassignments, the isolation, the way complaints disappeared. She told me that when she finally went to HR, the person who took her statement was the same person who later signed off on her termination paperwork. And then she told me something I hadn't known. There was another girl, she said, looking at her coffee cup. Before me, she didn't file anything. I only know because someone who was there at the time told me about it afterward. She left the state. That's all I know. But it happened. I didn't react outwardly. But inside, something clicked into place with the weight of a deadbolt. This went back further than 4 years. I passed that information to Ellis. 3 days later, he had found a record of small business dispute filing in a county court, buried in a docket that hadn't been digitized until 2022, that referenced, in a footnote of an unrelated matter, a prior employee separation at a firm that had operated under a predecessor name to Caldwell and Vance before a rebranding 7 years ago. The employee's name was redacted. But the nature of the complaint was not. 7 years. At minimum. I packaged everything into 3 separate folders. One for James Whitfield. One for the EEOC regional office. Addressed specifically to the investigator who had handled Angela's original charge. And one for a journalist, a woman named Dana Reeves, who covered business and labor for a regional outlet and who had, 8 months ago, Published a piece about NDA abuse in mid-sized firms that I'd read and bookmarked without knowing why at the time. I didn't send them immediately. I needed one more thing. Richard Vance was scheduled to speak at a Chamber of Commerce business luncheon. It was a public event, published on the firm's website and the Chamber's calendar. He was listed as a keynote guest. The topic was, without any apparent self-awareness, building cultures of accountability. I attended. I sat in the back row. I didn't introduce myself to anyone. I listened to Richard Vance speak for 22 minutes about trust, about the responsibility of leadership, about how the firms that would survive the next decade were the ones that invested in their people. He was polished. He smiled at the right moments. Several people in the audience nodded. When the Q&A opened, I raised my hand. He called on me. I stood up and I said, calmly, "Richard, my name is Mason Holt. My sister Carrie Holt was a junior marketing associate at your firm until May of this year. I have a question about accountability." The room shifted. Richard Vance's expression didn't break immediately. Men like him are trained not to let it, but something behind his eyes recalculated very fast. "I'm happy to speak with you after the event," he said, and his voice was steady. "I'm sure you are," I said. "I just wanted you to know I'll be in touch." I sat back down. I stayed for the rest of the luncheon. I shook 2 hands on my way out. And that night, I sent all 3 folders. I want to tell you what happened in the 3 weeks that followed, because the collapse didn't come all at once. It came in the way I'd seen it come before. In other cases, with other powerful institutions, not with a crash but with a sequence of threads, each one pulling the next. James Whitfield filed a motion to invalidate the NDA within 72 hours of receiving the package, citing duress, absence of counsel, and the documented retaliation timeline. The motion was 14 pages. The attached exhibits were 41. Sandra Oaks, Caldwell and Vance's outside counsel, responded within a day. Fast. Too fast, which told me they'd been expecting something, just not this much of something. The EEOC regional office, having received the consolidated file that connected Angela's prior charge to Carrie's case and the historical pattern going back 7 years, assigned a senior investigator and issued a document preservation notice to the firm. That notice required Caldwell and Vance to retain all HR records, internal communications, and employment files related to both cases. It also meant that anything they might have been planning to quietly delete was now evidence in a federal proceeding. Dana Reeves called me 4 days after I sent her folder. We spoke for an hour and a half. She had questions I expected and several I didn't. She was careful, exact, and when she told me she was going to need time to verify the historical records independently before publishing, I said that was exactly right, and she should take whatever time she needed. 2 days after that, something happened that I hadn't planned for. Derek Vance made a mistake. He sent Carrie a text message. It came from a number she didn't recognize, which was either very stupid or an indication that he'd used a secondary device without thinking clearly. The message said 3 sentences. I won't quote them exactly, but the meaning was plain. He knew she'd spoken to someone, he was advising her to remember what she'd signed, and there was a veiled reference to consequences if she didn't stay quiet. Carrie forwarded it to me within minutes. I forwarded it to James Whitfield, within minutes of that. James called me 20 minutes later, and for the first time since we'd started working together, I could hear something close to satisfaction in his voice. "That," he said, "is witness tampering." It went to the EEOC investigator. It went into a supplemental exhibit in the NDA invalidation motion. And it went, with Carrie's permission, to Dana Reeves as a documented example of ongoing retaliation. Here is something I've learned from years of watching institutions protect themselves. They don't fall because of the original offense. They fall because of what they do after they get scared. The original behavior can be explained, minimized, reframed. But fear makes people sloppy. Fear makes them send text messages they shouldn't send, shred documents that are already under preservation notice, call people they shouldn't call. Fear is the tell. Richard Vance called the Chamber of Commerce to have me removed from the membership directory. I wasn't a member. He called 2 people he apparently believed were professional contacts of mine to warn them away from working with me. Neither of them were contacts of mine. One of them called me to tell me about the conversation, confused and unsettled. The firm's Glassdoor rating dropped 0.4 of a point in a single weekend. Someone who had clearly been waiting for the moment posted a detailed account of their own experience in the HR department, using the specific language of someone who had been coached by an attorney on what they could and couldn't say without violating their own agreement. It was careful, incredible, and devastating. By the end of the 3rd week, Dana's piece ran. It was not a blog post. It was a 2,400-word investigative feature on the regional outlet's website, shared to their main social channels, picked up within 6 hours by a larger business news aggregator. The headline did not name Derek Vance by name that would come later, but it named the firm. It named Sandra Oaks as repeat outside counsel in employment separation matters. It named the time frame. It described the use of NDAs on unrepresented employees as a documented practice. It named Lindsay Marsh by her choice. She had agreed to be identified. She was living in Asheville now. She gave one quote. It was 4 words, "I wasn't the first." Within 24 hours of publication, 2 more former employees contacted Dana directly. Within 48 hours, a client of Caldwell and Vance, a mid-sized regional healthcare company that I recognized from the firm's website as one of their anchor accounts, issued a statement saying they were reviewing their agency relationship pending the outcome of ongoing investigations. Within 72 hours, Richard Vance's attorney contacted James Whitfield to discuss settlement terms. James told me on a Thursday afternoon. I was at my desk at work, and I took the call in a stairwell because I needed to be alone for a moment. They want to settle, James said. Quickly. Comprehensive terms. They're scared. What do we want? I asked, already knowing my own answer. Carrie needs to tell me what she wants, he said. Carrie and I talked that evening at my kitchen table. She had started a new job 2 weeks earlier, a contract position, nothing permanent yet, but real work that reminded her she was capable. She sat across from me with her hands around a mug, and I told her what James had said, and I watched her face move through several things before it settled. I don't want their money, she said. I mean, yes, I need some of it. But that's not the part I care about. What's the part you care about? She thought for a moment. I wanted in writing that what happened to me was real, she said. Not a performance issue. Not a culture fit problem. I want them to say what it was. And I want to know that whoever comes in after me doesn't walk into the same thing I walked into. We presented 5 terms through James. Full invalidation of the NDA with a written acknowledgement that the original signing conditions were improper. A formal written statement. For Carrie's records. Acknowledging that her termination was retaliatory and that her work performance had not been the basis for any disciplinary action. Mandatory third-party HR oversight for a period of no less than 3 years. Individual accountability for Derek Vance's separation from the firm, and a written statement that he was not eligible for rehire. A settlement amount that covered Carrie's lost wages, her legal costs, and a contribution to an employment rights organization of her choice. They pushed back on the Derek Vance term for 4 days. His father went quiet, which in my experience means a man is calculating rather than arguing, and calculation is actually more dangerous than argument. But the EEOC investigation was ongoing. Dana Reeves had 2 more sources. The healthcare client's review was still pending. The weight was already moving in one direction. On a Monday morning, James called me and said 4 words. They accepted all terms. I didn't celebrate. I'm not built that way. I sat in my car in the parking lot of a grocery store, which I realized later was almost exactly where Carrie had called me from the day she got her original offer, and I thought about Lindsay Marsh, saying I wasn't the first, and the woman who'd left the state before that, and how many years this had been happening in conference rooms that smelled like recycled air and corporate carpet cleaner. I thought about the fact that Derek Vance would face consequences, yes, but that Richard Vance had the resources to rebuild something very similar somewhere else, and that Sandra Oaks would likely keep practicing, and that NDAs would keep being placed in front of young women in rooms without windows and without lawyers. I thought about Dana's piece, still circulating. I thought about the EEOC investigation, still open. I thought about the 2 additional women who had come forward, whose cases were now part of a documented pattern that predated anything a settlement agreement could make disappear. The work wasn't done. It never is. But this part of it was. I drove to Carrie's apartment. She opened the door before I could knock, which meant she'd seen my car from the window, and when I told her, she didn't make a sound for a long moment. Then she laughed, the short, exhaled kind of laugh that isn't really about humor, the kind that comes when something you've been carrying for a long time finally touches the ground. We ordered food and we sat on her living room floor and we watched a terrible television show for 3 hours, and we didn't talk about any of it. At some point she said, without looking away from the screen, "You know what the worst part was? I kept thinking I must have done something to make it happen. Like if I could just figure out what I did wrong, I could fix it." "I know," I said. "But it was never about me," she said. It wasn't a question. She was saying it out loud because she needed to hear herself say it. "No," I said. "It wasn't about you at all." She nodded slowly and turned back to the TV. I stayed until she fell asleep on the couch, which she does when she's finally relaxed, and I turned off the light in her kitchen, and I drove home through empty streets with the windows down because the night was warm and I needed the air. There's something an old supervisor of mine used to say when a case closed in the right direction, he'd say. The goal was never to beat them. The goal was to make it cost more to keep hiding than to stop. That's all I did. I made the hiding expensive. I made the silence untenable. I used the tools I had: patience, documentation, the willingness to sit with information longer than most people are comfortable sitting, and I let the weight of the truth do the work that I couldn't do alone. Derek Vance is no longer affiliated with Caldwell & Vance. The firm's third-party HR oversight began the following month. The EEOC investigation remains active as of this writing, expanded now to include the full historical pattern. Lindsay Marsh is consulting with a separate attorney about her own case. And Carrie, last Saturday, accepted a full-time offer from a firm in Durham. She called me from their parking lot. She was crying again. Best way possible.